Now that we have some basic understanding of contracts and some of the requirements when it comes to contract law, we want to look at some of the more common provisions you see in different types of contracts. For example, right now, we've already talked about the agency agreement, right, that creates the agency relationship between the agent and the principal, whether it be buyer or seller. But what we're going to look at right now are just common provisions. Now, look, not every agency contract or not every contract of sale reads the exact same way. There are different versions of these contracts. However, typically, the provisions we're about to go over are pretty common. Some of the wording might be a little bit different, so you'll just have to get familiar with the contract that you're using in your market. Okay? And we're not going to get into the exact verbiage of any of these provisions anyway. We just want to make sure you at least have some understanding of one, what kind of provisions could we expect in an agency contract, and what does it mean? And that's what we want to take a look at right here. And I will say also, I've had people say, well, do I need to memorize all the provisions in an agency contract? No. They're not going to ask you to list every provision in an agency contract. However, could they ask you about any one of those to make sure you understand what it is, what the requirement is? They could do that. But don't try to just memorize all the provisions. That's not necessary at all. So let's look at what we might find in an agency contract. One, we're talking about property data or requirements. Now you have to put in the agreement what your client is asking you to do. Basically, so if you're representing the buyer, you need to find out what are the buyer's requirements. What size house, how many bedrooms, do you want a garage? What area of town, or what price range, stuff like that. What requirements are you looking for in the house? Otherwise, you don't even know what to search for. If you're representing the seller, you're getting ready to list a house, and there's a lot of property data that you're going to need to identify. It's a lot of stuff, trust me. We'll get into sources and stuff like that where you can get this data when you get into the next course, the Unit 2 part. But really, this first provision is just to identify what the buyer needs are or what the seller's needs are. And then you have to list all that in the agency agreement. The next provision says we must be able to distinguish between what's realty, personalty, and fixtures. In other words, make sure everybody understands what stays and what goes. In an earlier chapter, we already talked about the differences between real property and personal property, right? And when you're dealing with contracts of sale, remember we said contracts of sale are only valid to convey real property. Now, when you see the word realty there, realty is just another term for real property. Personal property is anything that's not attached, right? And then fixtures are basically personal property, but they have been attached to real property. And just to be clear, fixtures, once they're attached, they stay. That's included with the sale because it's been attached to real property. Personal property, things that are not attached, furniture, stuff like that, that's not included. But it's just imperative that both you and the seller, and if you're representing the buyer, make sure the buyer understands as well what's staying and what's going, what's included, what's not included. Because I'm telling you, this is where issues crop up When the buyer thinks something is included with this sale and the seller has no intentions of leaving it, whatever it is. So y'all just make sure all this is perfectly identified and all parties are on the same sheet here. Again, if you're representing the seller, you have to agree on the sales price. What kind of price are we looking to sell the property for? Obviously, if you're representing the buyer, then you would put like a price range. Okay, somebody might say, I'm looking between $250,000 and $275,000. Something like that. But all that, again, you must put in the agency agreement. We have to agree on what the compensation will be and how that will work, right? The commission. We know commission is always negotiable. So you and your client need to come to some agreement, and then that agreement must be stated in writing in the agency agreement. Typically, at least in the market I'm in, I think probably the most common way to agree on the commission is some percentage of the sales price. I'll charge you X percent of whatever it sells for as my commission. Even though that's a very common, maybe the most common way we negotiate, it doesn't have to be a percentage. It could just be some flat fee. You could say for X amount of dollars, regardless of how much it sells for, this is what you owe me when it sells, okay? And then if you're representing a buyer, same thing. You need to agree with the buyer on how your compensation will work and how much compensation you expect to get. The buyer's agent may actually try to negotiate with the listing agent to try to get their commission paid by the sellers or from the seller's proceeds. So basically the seller might be paying not only their listing agent's commission, but also the buyer's agent's commission. Now, they don't have to pay it. Again, this is all negotiable. But if the seller does not pay any commission, then you may need to have made other arrangements or an agreement with your buyer that buyer, if the seller doesn't pay it, then buyer, you're going to have to pay it, right? All this stuff has to be included in the contract. I'm telling you, if you don't have it there, if it's not included, don't expect to be compensated. Okay? But you've got to be very detailed on exactly how much the commission is, where is it going to come from, how's it going to work, all that stuff. You got to be very detailed on how you intend to be compensated. The next provision says we have to have signatures of both the principal and the agent. I don't want to get too deep into the weeds here, but this is a pretty big deal here. First of all, it says we got to have signatures of the principal and the agent. Well, first of all, who's the principal? Remember we said the principal is whoever you're representing. Could be the buyer, could be the seller. So when they say principal, either buyer or seller, whoever your client is, they have to sign this contract. But who else does it say has to sign the contract? The agent. Now, if you remember from our agency chapter, who's the agent in a real estate contract or agency agreement? Remember, the agent is always the broker in charge. So would that be you if you're not the broker in charge? No. So should you, as a licensee, or the other term you might hear called is a sub-agent, because you're a sub-agent to the agent, should you ever be signing the listing agreement for the seller if you're listing the house, or a buyer's agreement if you're representing the buyer? No. Even if you do sign it, it's not valid. you're not a party to this contract. Y'all, who are the parties to the contract? The principal and the agent. Okay? So just beware. Y'all, the reason I'm bringing this up, I know at least in the market I work with, y'all, it is very common. Sub-agents, y'all, licensees are signing these agency agreements. And I would argue there's no the contract's not valid because you're not a party to the contract, right? Y'all, it states who the parties are. It's typically the very first paragraph is where you identify the parties. In fact, it's a fill in the blank. And you write the buyer's name or buyers' names into there. So now we've identified the principal. And then it also says, and the broker in charge of, and then typically you fill in the blank with whatever company you're licensed with. So it doesn't say a licensee with X company. It says the broker in charge of the company. So it's there we've identified who the parties are, who the principal is, and who the agent is. So I'm just telling you, if you get it licensed into one of these companies and they're telling you it's okay to sign an agency agreement, I'm telling you, I think you could have problems down the road if issues crop up. Because I think you're working under an agreement that's not valid. Okay? So anyway, got to be signed by the principal and the agent. Y'all, the next provision says we have to have a specific expiration date. Now, y'all, that one's critical. I'd be shocked if you don't get asked about this. Y'all, there has to be an expiration date in the contract. Y'all, this agency agreement must expire at some point. Okay? Y'all, in most states, I know certainly in the state that I operate in, but in most states, y'all, they have there are state laws that will not allow you to have an automatic extension clause. Y'all, if you're not familiar with what I'm talking about there, y'all, they might have a provision or clause here that says maybe they'll put an expiration date of September 15th of whatever year. But then they'll have a statement that says, but if the principal really wants this contract to expire on September 15th, then you must notify the agent within 30 days of it expiring, or some other number, in writing. Otherwise, it will automatically extend for another 6 months or a year or whatever they put there. That's just some automatic extension clause. Y'all, those are not legal, certainly in the state that I operate isn't, and I don't think it's legal in most states, honestly. So make sure you know what your state laws are, and we'll take a look at that when we get into the state-specific portion, okay? But y'all, there has to be an expiration date. Now, the law does not say how long or how short. Y'all, you could do it for 1 day. You could do it for 1 month. You could do it for 6 months, a year, or whatever. But, y'all, there has to be an expiration date. Y'all, if they ask you a question, which of the following provisions must be included in an agency agreement, I promise you the one they're going to be looking for is a very specific expiration date. Y'all, that has to be there. Then obviously whatever services you agree to perform, y'all, you can't just tell the seller, I'm going to do this, and this. All these wonderful things I'm going to do to sell your house and not put it in writing. I know this might sound or be a little bit of a shock to some of you, but y'all, not all people, much less agents, licensees, will actually do everything they promise to do. I know that's a shock, but it happens. So therefore, if you say you're going to do something or some service you're going to provide, it must be included in the agreement. Make sure it's there. Then we look at how and when the agent earns their compensation. And we've already talked about this a lot already, but as far as the how, how do we determine the commission? It's always negotiable. So whatever you and your client agreed to, then that's what it's going to be. But as far as when, now you notice it states here, how and when does the agent earn the compensation? I think most, excuse me, most people, to include veteran agents, they believe you've earned your commission once the transaction is closed. That is not what most agency agreements read. So maybe you want to read your, in the market you're in, make sure you read your particular agency agreement. But every single one I've ever read, it specifically states that the commission or compensation is deemed earned at the time the contract of sale is agreed upon. So once the buyer and seller have a ratified contract, they both agreed on the purchase and sale of the property, at that moment, I've earned my commission. Whether it closes or not, I've earned my commission. Now, it does go on and say that, that I will agree to put off payment of the commission until closing. But that does not mean it has to close for me to earn or get paid my commission. Okay? So when is the commission deemed earned? If they ask you that question, at the time the contract has been agreed upon. Once you have an agreed upon contract of sale, you now owe me the commission. There is no requirement that it has to close. And I will tell you, typically, if it doesn't close, I don't know of any agents that will insist on compensation, even though legally they may in fact be due the commission. If it doesn't close, typically we just let it go and try to get another house under contract, and hopefully it'll close. But just make sure you understand that part of it. The next provision is actually talking about retainer fees, and I'm a big fan of retainer fees in certain situations. I don't think probably most agents, again, I'm just speaking primarily in the market that I work in. Maybe in the market you're going to be working in, this might be a lot more common. But here in my market, you just don't see agents do this very much. Retainer fee is some amount of money you might charge your client to be paid up front before you even provide any services, whether it be buyer or seller. I will tell you, I have used the retainer fee, and typically when and if I do, it's with buyers. I don't think I've ever charged a seller retainer fees. But I have charged buyers, and the only reason I even do this with buyers, honestly, a lot of buyers, they're just not being very honest. They say they want to buy a house, and then they kind of hide the fact that they can't buy the house for whatever reason. Maybe they can't get a loan or whatever. At the end of the day, so you wind up spending weeks or months, in some cases, showing house after house after house after house to buyers, and then they never buy anything. Well, if they never buy anything, then you don't get paid. And I've wasted all this time, gas, money, aggravation, and I don't even get paid for it. So in some cases, I will go ahead and charge a retainer fee. Now look, the buyer may not agree to pay it. Now if you don't agree to pay it, then fine, go bother somebody else, the way I see it. But if you're going to charge a retainer fee, and obviously whatever amount you feel is practical, then that's what you would charge. But if you're going to charge it, then here's something else you must agree to. obviously, the retainer fees will not be paid back, y'all. So buyer, you're not getting this money back, period. Whether you buy a house or not, you're not getting it back. I'm keeping this money to cover my expenses in trying to help you find a house. But what happens when the property does close? Y'all, they actually buy a house, it closes. You get paid a commission, right? Whatever the commission is you agreed to. Does this retainer fee, is this over and above the commission? Or will that retainer fee be subtracted from the commission you're due? Yeah, I'm asking that question because you could do it either way. But obviously that has to be agreed upon up front when you sign this contract. So if you're saying, no, this is over and above the commission, then you better put that in the contract and make that very clear. Here's how much I charge in retainer fees. This will not be subtracted from the commission. This is over and above the commission. Or if you're going to agree to subtract it, then you need to put that in there as well. So again, it just needs to be very clear and in writing, especially when it comes to compensation of any kind, to include these retainer fees. We have to make sure all parties understand the type of agreement you've entered into. Again, if you recall back in the brokerage relationships or agency chapter, there are different types of agency contracts. You could have the exclusive right to sale, an open listing, or an open or buyer's agency agreement. Remember there was at least 2, maybe 3 different types of agency agreements. Just make sure whatever type of agency agreement you're using, that's specified. And typically it says it right at the very top. Exclusive right to sell or exclusive right to buy. Obviously the exclusive right to buy or sell, that's the one that protects you the most. Basically meaning if you buy a house or sell a house under any circumstance, I get paid, right? So just make sure we've identified those things. If you and your seller, typically where it's talking about exceptions and variations in commission, this is typically something common with sellers, but it could also be with buyers. Any variations or exceptions, you must identify that, what those are and exactly how that exception is going to work. Now you think, well, what does that mean? In fact, a lot of times, again, in our market, we refer to it as a variable commission. Where, and there could be any number of examples, but probably a very common example is, I might tell the seller, and I'm just making up using numbers just to make a teaching point. This is not to suggest what you should or should not charge, so don't go down that road. But I might say, seller, I'll list your house for 6% commission. Meaning, when it sells, you owe me 6% of whatever the sales price is. However, seller, if I can find the buyer myself and there are no other agents involved, in other words, good chance we're talking about dual agency. It doesn't have to be dual agency. But at any rate, I'm telling the seller, if there are no other agents involved, meaning no other agents to pay money to, then I'll just charge you 4% commission. That's just some variation where I'll charge you X amount if this happens, but I'll charge you this amount if this happens. So whatever those variations are, they must be very clear in writing and made part of the contract. Then it says we have to make sure we provide copies of this agreement to the client. Now, I'd be careful here, especially potentially for test purposes. We talked earlier about who has to sign this contract. the principal, and the agent. Remember, we said the agent should be the broker in charge. In fact, the agent is the broker in charge. So, if I were to ask you, at what point must you provide a copy of this agreement to the client? You might have an option or an option for an answer that says at the time the client signs the contract, which sounds reasonable, doesn't it? Whenever they sign it, then you need to give them a copy of it. But in reality, that's not very practical, because typically if I'm sitting down here with the seller, and chances are, guess where I am when I'm sitting down here with the seller? Usually at their house. But yeah, they've signed it, but who else has to sign it? The broker in charge. That means I got to get back to the office, or through some electronic means, but at any rate, I have to get my broker in charge to sign it. So the right answer is probably not going to be at the moment or at the time the client signs the contract. The right answer would be when all parties have signed the contract, right? Otherwise, what good does it do to give them a copy of the contract that they signed, but the agent hasn't signed it yet? Just be careful they don't trick you into something like that. But point we're making here is you must provide a copy to your client. The next provision is something called the Broker Protection Clause. This is a pretty significant provision, and it does exactly what the title of this provision might suggest. It's to protect the agent or broker from unscrupulous clients. I know this might sound like it would be kind of far-fetched, but I'm telling you, it's not. Stuff like this happens all the time. Where I just give you an example, a personal example. I had a listing, or excuse me, I was representing a buyer, and the buyer contacted me about wanting to go look at a particular house, so I set it up. We went and looked at it. The homeowner was still there, which really doesn't bother me that much. It's usually not. I'd prefer them not to be there, for obvious reasons. But I'm not too bothered even if they are there, as long as they don't get in the way and interfere. But anyway, when we got through looking at the house, we and walked outside about getting ready to get in our vehicle. I just asked the buyer, I said, what do you think? Is there anything you think you might be interested in? He said, Frankie, absolutely not. Forget it. This was a complete waste of time. I didn't like nothing about this house. Moving on. So I got in my vehicle, they got in theirs, and we drove away. Well, what I did not know until after the fact, as soon as I drove away, my buyer turned around and went right back to the house and started talking directly to the seller and told the seller, obviously they were interested in the house, they wanted that house, and told the seller this: if you'd be willing to just let your listing agreement with your agent expire, let's just wait on it to expire, however long that would be, then I'll buy your house, I'll pay you full price what you're asking for, minus whatever the commission would have been if you had to pay commission. That could have been 10, 12, 15,000, whatever it was. That's just wrong. So my point is, you can have, your clients can try to go behind your back and cheat you out of a commission. I caught it in time, and I was not happy with that client. But anyway, So how did we fix that? Y'all, so now we've got in our contract something called a broker protection clause, where basically what is said, and I'm kind of paraphrasing here, but basically, y'all, for example, if I'm representing a buyer, it might say, buyer, if you should decide to purchase any property that I showed you during the period of our agency agreement within blank days, y'all, and it's a fill in the blank. Y'all, you can put, a month, 6 months, year, whatever. But say it said 6 months. So buyer, if you decide to buy the house, any house that I showed you within, say, 6 months of our agreement expiring, then you still have to pay me a commission. Y'all, and that same provision is in the listing agreement with the sellers. So basically, they're just saying, you can't just wait for our agency agreement to expire and then go buy the house that I've already showed you and think you don't have to pay me. So, that's what the broker protection clause does. Now, we'll tell you, at least on part for the seller, if the seller, say your listing agreement expires and they decide to relist their house with a different agent, as long as they relist it with another agent, then obviously their intent was not to try to cheat anybody out of commission. Otherwise, they wouldn't have hired another agent. So if they hire another agent, then that voids this clause. You can't be mad at the seller for going with a different agent if you did not sell it within the time period you stipulated in the contract, right? That's not the seller's fault. That's your fault. You didn't sell it. They have every right to try to get somebody else to sell it. All right, so that's the broker protection clause. And then finally here is the multiple listing clause. And basically what this clause, now I will tell you, this provision works a little bit differently from one MLS to another MLS. So again, this would be something you would want to make sure you know what your MLS bylaws are when you decide to join the MLS. But basically what it's saying is this: if you list, assuming you're a member of the MLS, when you list a property for sale, you must put it in the MLS and make it available to cooperating agents, to other agents in the market. You cannot just list the house or property and decide, I'm not going to put it in the MLS because I don't want another agent to bring a buyer to it. I want to find the buyer myself and get paid more money. You're going to get in trouble when you get caught doing that. And you could very well be disbarred from the MLS. So, and where this could vary from MLS, from one MLS to another, is, how much time do you have from the moment you list the property until it must be put into the MLS database? That amount of time could vary. So I'm not going to get into how much time that would be. Not that big a deal. Just want you to understand what the clause means. It just means you've agreed to list any properties you list must be entered into the MLS database, right? So those are the provisions, common provisions you will see in an agency agreement.